All right, in this video, I will explain the 5 contract clauses costing Florida CEOs millions in 2026. And by the end of this video, you'll learn which clauses to hunt down in your contracts today and exactly how to neutralize them before they destroy your bottom line. I'm Santiago Cueto, board certified international business law expert and best-selling author based right here in Miami, Florida. Look, I reviewed over 10,000 business contracts in my career. I'm showing you these 5 clauses because I've seen the damages that they cause when CEOs ignore them. Just recently, a Florida CEO lost $3 million because of 7 words buried in page 14 of his supplier agreement. He never saw it coming, and his attorney never flagged it either. The clause sat dormant for 3 years until his biggest competitor triggered it last month. And this isn't an isolated incident. Right now in Florida, business leaders are hemorrhaging money because of contract clauses they signed years ago. These clauses are ticking time bomb, guys. Some activated when Florida's new business laws took effect last year. Others became dangerous because how Florida courts started interpreting them in recent cases. Now let's start with the clause that's catching the most CEOs off guard right now. The first clause draining CEO bank accounts is the outdated non-compete provision. You might think you understand your non-compete, but you don't. Florida completely reformed its non-compete statute last year. The courts are now throwing out agreements that would have been enforceable 24 months ago. Now here's what's changed. Florida courts now require non-competes to specify an exact geographic radius. Phrases like throughout Florida, those no longer hold up. You need to be specific. You need precise miles from specific addresses. If your agreement says the greater Miami area, a judge will likely void the entire clause. And the time restrictions also shifted. Courts are now scrutinizing any non-compete longer than 12 months unless you can prove extraordinary circumstances. That 3-year restriction you negotiated with your former partner, it's probably worthless now. Now here's where CEOs are losing millions. Let's say you sold your company 2 years ago with a non-compete attached. You took the payout. You signed the paperwork. Now you want to start a new venture in the same industry. Under the new interpretation, your old non-compete might not be enforceable. But here's the trap. If you violate it and you're wrong about enforceability, you're liable for damages. And if you don't pursue your new opportunity because you think you're bound, you're leaving millions on the table. One CEO I know walked away from a $7 million opportunity because he assumed his non-compete was ironclad. We reviewed it last month, and it turns out it would never survive a court challenge under current Florida law. He missed his window. The opportunity went to someone else. You need to pull every contract with a non-compete clause. Have an attorney review them under current Florida standards. What was binding in 2023 might not be binding today. Now, the second clause destroying CEO wealth is the improperly drafted force majeure provision. This matters in Florida more than almost anywhere else. Force majeure clauses excuse contract performance when extraordinary events occur. Think hurricanes, floods, or government shutdowns. Florida CEOs face these events regularly. Your force majeure clause should protect you, but most don't. And here's the problem. Generic force majeure language doesn't cut it anymore. Florida courts started applying a much stricter interpretation after the 2024 hurricane season. If your clause just lists act of God or natural disasters, you're vulnerable. Courts now require specific enumeration of covered events. You need to explicitly state hurricanes. You need to specify flooding. You need to list power outages and supply chain disruptions. Generic catch-all phrases no longer provide protection. One Miami-based CEO learned this the hard way. Hurricane season shut down his ports for 2 weeks last fall. He couldn't fulfill a major delivery contract, and his force majeure clause said natural disasters and acts beyond reasonable control. He thought he was covered. The court disagreed. The clause didn't specifically mention hurricanes or port closures. He was liable for the full breach. The judgment was $2.4 million. Let that sink in, guys. $2.4 million. Hey, by the way, if this video is saving you from contract disasters, Hit that like button right now and subscribe to this channel so you don't miss the warning signs in your other business documents. These insights could be worth millions to you. Now let's talk about clause number 3. The third clause, bleeding CEOs dry, is a reciprocal indemnification provision. This sounds technical, but it's actually deadly simple. Indemnification means one party agrees to cover the other party's losses under certain conditions. Now, reciprocal means both sides agree to indemnify each other. It sounds fair, right? But it's not. Courts recently ruled that reciprocal indemnification clauses must have balanced cap limitations. So if your indemnification caps aren't symmetrical, the entire clause can be deemed unconscionable. That means unenforceable. And here's where CEOs get destroyed. You sign a vendor agreement 5 years ago. You agree to indemnify the vendor up to $500,000, and the vendor agrees to indemnify you up to $50,000. You didn't think much about it at the time. The deal was good. You needed that vendor. Now fast forward to today. The vendor's product causes damage to your customer. Your customer sues you. You try to bring the vendor in for indemnification, but the court looks at your agreement. The caps are imbalanced by a factor of 10. The judge throws out the entire indemnification provision, and now you're holding the bag for damages that should have been the vendor's responsibility. This happened to a Jacksonville CEO just 3 months ago. His manufacturing equipment failed. It destroyed a client's entire production run, and the damages exceeded $2 million. His vendor agreement had a reciprocal indemnification clause, but the caps weren't balanced. The court voided it. He paid the full $2 million himself. So pull your vendor agreements, look at every indemnification clause, check the caps on both sides. If they're not proportional to the risks each party creates, renegotiate now. Don't wait until you need that protection. Now the fourth clause causing CEO financial carnage is the automatic renewal provision paired with inadequate termination notice requirements. This combination is particularly vicious. Many contracts automatically renew unless you provide written notice of termination, and that's standard. The devil is in the timing and method requirements. Florida courts now enforce notice requirements to the letter. If your contract requires 90 days written notice before the renewal date, 89 days doesn't count. If it requires certified mail, email doesn't count. If it requires notice to a specific person at a specific address, sending it to the general company address doesn't count either. Here's how this destroys CEOs. Say you have a software licensing agreement that costs $300,000 per year. It auto-renews every January 1st. It requires notice 120 days before renewal. You decide in October that you're switching providers. You email the company. You think you're done. January rolls around. You get an invoice for $300,000. You protest and you show them your email. They show you the contract. Email wasn't sufficient. Certified mail was required. The notice period wasn't met anyway. You're locked in for another full year, and there's no escape. You now pay for 2 software systems, your old one and your new one. Now, a Tampa CEO just paid $900,000 because of this exact scenario. His contract required notice to the company's registered agent, not their general business address. He sent notice to their billing department. It doesn't count. He's paying for service he doesn't use for 18 more months. Guys, this is serious. Look at the notice requirements. Go through every recurring contract. Mark renewal dates on your calendar 180 days in advance and identify the exact notice requirement. Set reminders to comply perfectly if you want out. Now, the fifth clause destroying CEO wealth is the out-of-state jurisdiction and venue selection provision. This seems administrative, but it's financially devastating. Jurisdiction determines which state's laws govern your contract. Venue determines which court will hear the dispute. Many contracts specify both. Now, Florida CEOs often sign agreements that put jurisdiction and venue in New York, Delaware, or California. Well, here's the nightmare. You have a dispute with a supplier. Your contract puts jurisdiction in Delaware. You're based in Fort Lauderdale. You now have to hire Delaware attorneys. You have to travel to Delaware for depositions and hearings. Your legal bills triple immediately. Delaware courts move slower than Florida courts. Your case that would resolve in 8 months in Florida takes 2 years in Delaware. During that time, you're bleeding legal fees every single month. Even if you win, you just spent hundreds of thousands of dollars on a case that should have cost far, far less had it been in Florida. A Florida CEO recently spent $400,000 litigating a contract dispute that should have cost $150,000. The only reason? His contract specified California jurisdiction and venue. He had to hire California counsel. He had to fly his team to California 6 times. The delays were extensive. And here's what makes this worse. Florida courts are currently very business-friendly for Florida-based companies. When you agree to out-of-state jurisdiction, you're giving up home court advantage. You're also giving up cost efficiency. So review every contract, look for jurisdiction and venue clauses. Fight to keep disputes in Florida whenever possible. If you can't eliminate the out-of-state provision, negotiate for binding arbitration in Florida instead. It's still better than litigating in another state. Now, these 5 clauses are costing Florida CEOs millions of dollars right now, but you might have these exact clauses sitting in your contracts today. Every day you delay is another day of exposure. Start with your biggest contracts. Pull them out today. Review these 5 areas immediately and flag anything that's questionable. Get proper legal review on anything that looks like these clauses. That CEO who lost $3 million I mentioned at the start, well, he's my client now. We're rebuilding his contract infrastructure, but he can't recover what he already lost. Don't be that CEO. Protect yourself now. Now, if you found this valuable, show your appreciation by liking this video and subscribing to my channel. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.